Hello and welcome to The Big Picture. The logjam in the parliament during the ongoing monsoon session has hampered the functioning in both houses. While for the last 2 days the Lok Sabha has witnessed some business after 25 Congress MPs were suspended for this week, the Rajya Sabha with the government in a minority has continued to face disruptions with hardly any work done. Meanwhile, the government has been handicapped severely with many of the key legislations like the Land Bill and the GST Bill, among others, getting caught in this logjam. One of the way out being suggested in certain quarters, both within the government and outside, is to convert some of the pending bills into a money bill so that the consent of Rajya Sabha becomes redundant. A money bill entails that it be passed in Lok Sabha, and even if it is not passed in the Rajya Sabha, it becomes a law. The proponents of this measure feel that it is the only way out of this logjam. It may be recalled that in the budget session, the government had managed to get the black money bill passed by converting it into a money bill. We will discuss today the feasibility of converting bills into money bills and which of the bills can be turned into a money bill and what are the hitches in doing so. And if this is the only way out and what is constitutionally permissible. To discuss this, I have with me N.K. Singh, a former MP and also former Revenue Secretary in the Government of India and also a former member of the Planning Commission, P.D.T. Achari, former Secretary General Lok Sabha, and Smita Gupta, political editor of The Hindu. Welcome to all of you. Mr. Achari, this debate, is it a new one? Converting money, bills into money bill, is it a new one? Has there been a history of this in the Parliament?
Well, it's a new discussion, it's a new debate, and I have never heard about a bill being converted into a money bill, because according to me, that is not just possible. Why? Because Article 110 deals with the money bill. It lists out certain subjects, about 7 items,
right,
which form the subject matter of a money bill, and only these items will form the subject matter of a money bill. And if the bill contains anything else also, then it is not a money bill. So the Constitution is very strict about the money bill, and therefore I would say that it is not possible, and it's not feasible.
We will come to the feasibility or otherwise, factor a little later. But Smita, do you think that, we have had this, we have seen this happening just in the last budget session, as I mentioned earlier, the black money bill, which was facing problems in the Rajya Sabha, which could have faced problems in the Rajya Sabha, came as a money bill, and then it got passed. So now, why is this issue cropped up again?
See, even at that time when that black money bill came up, designed as a money bill, that time a CPM MP had registered his protest. Many of the opposition had given it in writing to the chairman of the Rajya Sabha that this was not correct and that he should look into it. Subsequently, the chairman of the Rajya Sabha, Mr. Hamid Ansari, had said that the person who decides whether a bill can be a money bill is a speaker of the Lok Sabha. And there that debate had sort of, for that moment, had ended. Now in this session, what has happened, thanks to all the issues of corruption and conflict of interest, allegations that have been leveled against ministers and chief ministers belonging to the BJP, the opposition, largely led by the Congress and the left, Parliament has not been functioning. Things came to a head on Monday when 25 Congress MPs were suspended. So now nothing, in this session, till this week, nothing was happening. This week, I think only supplementary demands and grants have been passed, and some one or two minor bills in the Lok Sabha. So for the government, they are kind of facing a kind of paralysis. If no key bill critical to the government's agenda is passed, then how does the government take forward its agenda? So it's again gone back to what it did. In fact, even at the time of the union budget this year, there were certain items that were inserted and the opposition MPs had raised objections, saying that you cannot insert them into the budget. Because, as they point out, virtually any bill has a money component, but that doesn't necessarily make it into a money bill.
Right, right.
And I presume the concept of a money bill was why it said that even if the Rajya Sabha does not pass it, if it lies there for 14 days, it becomes, so that government never stops. Money must flow.
That's
but
right.
that doesn't mean that all critical laws should be converted into money bills.
Okay, so you think that there is some kind of a thinking that if nothing works, we'll have to do this?
Yes, because I think people are also looking at the Gujarat Assembly when the current Prime Minister was the Chief Minister. At that time also, if one looks back at the records of the Gujarat Assembly during that period, the Assembly used to run for 2-3 days. Most of the time the MLAs used to be, opposition MLAs used to be suspended, and whatever bills had to be passed used to be passed during that period. So, but you cannot bypass legislatures and parliament when it comes to passing bills.
Mr. N.K. Singh. Mr. Singh, the question is, let us look at the larger issue. We will come to the specifics a little later. What Mr. Achari says is that, converting bills into money bills is something which normally doesn't happen. According to his own experience, he says that it has not happened. But we have seen it happening in the last session, in the budget session of Parliament. So how do you look at this entire issue?
No, frankly, I think that I totally agree with Mr. Achari that you cannot convert a bill into a money bill. Either a bill is a money bill ab initio, or it is not a money bill. The procedure for classifying it as a money bill has been stipulated in the Constitution.
Right.
Article 110 stipulates the broad provisions. But one difference, of course, we must note that there are various items which have been listed in the Article 110, but the prefatory clause of Article 110 says if one or all of these,
all or any of the following matters.
One of those,
right,
is all or any of the following matters is the prefatory clause.
Right.
So I think that even if one of those get attracted, I mean, technically speaking, a plea can be taken for introducing this and treating this as a money bill. But here there are, I think, 2 or 3 very serious problems. First of all, I think that it is quite clear that a constitutional amendment bill, which this GST is, a constitutional amendment bill cannot be a money bill. Because I think that the...
I mean, you mean it cannot be converted into a money bill?
President first of all, there's no conversion.
There's no
conversion. If it has to be done, it will have to be, I mean, if there is at all an intention, it will have to be, I think, introduced ab initio as a money bill after following the due procedures which have been prescribed in the Constitution.
Correct.
And since the assent of the President has not been taken in this GST prescribed under Article 117, which is so for all money bills,
right,
the assent of the President is taken before the legislature can take it up. That has not been done. So a constitutional amendment bill cannot, in my opinion, be treated as a money bill, since that is the structure of our federal entity. I mean, after all, in the GST, 50% of the legislatures have to really also approve this. And there is no provision in which the assent of the legislatures can be taken for granted, and a constitutional amendment bill can become a money bill. I mean, so far this has not been the precedent. So I totally agree with Mr. Acharya. There is no question of converting anything into a money bill. The due procedures would have to be gone through for treating this as a fresh bill, and for this to be subjected to the scrutiny on the basis of which the Speaker has, of course, to be satisfied, and the powers of the Speaker in this case, as rightly pointed out, appears in the Constitution to be quite supreme, because Article 110.3 or 110.4 says that the decision of the Speaker on whether or not it is a money bill is a final decision.
Right.
And that's a power that the Speaker derives from provision of the Constitution itself. So that is my broad reaction on this whole question of whether GST can be treated, how does it become a money bill or not?
Okay. Yes.
If I could just add to what Mr. N.K. Singh said, on the GST bill, he's absolutely right. And in fact, those people in government who are proposing that certain bills should be classified as money bills to overcome also made it clear that the GST bill, being a constitution amendment bill, could not be classified.
Could not be classified.
Even those who are proposing this
okay.
idea.
Mr. Acharya, how did the black money bill then become a money bill?
You know, there were actually...
What were the provisions? What were the provisions there which could, which could be brought into this category?
I will briefly explain what exactly is the money bill. Let us understand
that's
that.
important.
You know, as Mr. N.K. Singh was rightly saying, Article 110 deals with this, and Article 110 very specifically says that only one of these items, only, that word only has been used in the main body of that article.
Yes, only provisions dealing with all or any.
Bill.
But you know what Mr. Singh said, all or any.
No, all or any. A bill can contain all the listed items.
Yes, there are.
But only these items, not anything else.
There are 7 items.
I'm telling you, if a bill, for example, contains anything other than these items, then it is not a money bill. So a money bill, pure and simple, that has been defined by Article 110. And of course, it says there are 6 items which are specific items.
7.
No.
Oh, 7th is any matter.
Incidental.
Yes, any matter.
Incidental to any of these items.
Right.
So, that is the thing. Any of these matters and any other things which are incidental to that matter.
Doesn't that give a broad, scope for
That depends on the subject matter of the bill. But the point is, the Constitution is very clear on this issue, that it has to be very strictly construed. This provision relating to the money bill has to be very strictly construed. Certainly, the power to classify or certify a bill as a money bill has been vested in the Speaker. That is because, Speaker is the presiding officer of the House of the People, and House of the People in our constitutional scheme has the powers with regard to finance.
Right.
So that is why it has been vested in the Speaker. But now there is a point may arise, or a situation may arise. The Speaker has either deliberately or otherwise certified a bill as money bill, which is not strictly speaking a money bill.
Right.
It can happen.
It can happen. No, that's why I'm asking you specifically.
Yeah.
As far as black money bill is concerned,
I'm giving a broad hint about that. Actually, the point is, suppose a Speaker certifies a bill as a money bill, which is not a money bill, strictly speaking, then what is the remedy? Constitution doesn't say anything about it.
The Constitution says that it cannot be challenged in a court of law.
No. Constitution doesn't say that. I'm telling you that. I will clarify that. Actually, and then this bill goes to the Rajya Sabha. If it is a money bill, Rajya Sabha, even if it can only make a recommendation.
Exactly.
And those recommendations may be accepted or may not be accepted. And if the Rajya Sabha sits quietly, it doesn't do anything, after 14 days, the bill will be deemed to have been passed by both the houses in the form in which the Lok Sabha has passed it.
Right.
So this is the provision. Now the question is whether there is any remedy available to the members of the Rajya Sabha. The point is, Rajya Sabha, if it is a money bill, Rajya Sabha doesn't have the same power as the Lok Sabha.
Right.
And Rajya Sabha doesn't have the same power which they have in case of other bills.
Other bills.
So that is a serious limitation on the Rajya Sabha. If a bill which is not a money bill but which has been certified as a money bill goes to the Rajya Sabha, that means you have curtailed the power of the Rajya Sabha in effect. Now if that happens, what is the remedy? Now you asked about the...
black money bill.
No. You said people cannot go to court.
Yes.
That judicial remedy is not available.
That is the common perception.
No, the point is, Article 122 says that on the basis of procedural irregularity, you cannot challenge what happens in the House in a court of law.
Right.
Procedural irregularity, which means if it is another matter which is not a procedural irregularity, you can certainly challenge it in the court. That is also there. Now, if you look at this provision, you will know that it is not a procedural irregularity. This is a matter, this is a constitutional decision with the speaker gives a constitutional power which has been vested in the speaker. After all, the constitution, you know, has put a certain faith on the speaker. It means the speaker will give the correct decision. So, after all, you are depriving the other house of parliament.
So you're actually saying that the speaker's decision can be challenged in a court of law?
Well, there can be an interpretation like that.
There can be an interpretation. Mr. Singh, would you like to, you know, what do you have to say on this? Is there such a possibility, one thing? And second, how did black money bill become a money bill?
No, I think that as far as the black money bill is concerned, I mean, I believe that the government had obtained the opinion of the senior law officers before government submitted it for the consideration of the speaker. And as has been rightly pointed out, that as far as the constitution is concerned, the constitution is completely clear that the decision of the speaker in classifying this as a money bill is a final decision, and that was the course of action which was followed as far as the black money bill is concerned, even though, as has been rightly pointed out, that particular bill, apart from making provisions, stringent provisions in regard to black money, also amends two other collateral laws. It amends in the same process, the money laundering bill,
right,
which was of course a separate bill, and it also amends the FEMA, the Foreign Exchange Management Act,
right,
as part of the same bill. And these matters were raised, of course, in the Rajya Sabha by some members from the CPM and perhaps from the other parties. But at that stage, it is very, very clear that the decision of the speaker is final, and the bill was taken up, and really the bill has now been enacted into law. Now, whether or not this can be subjected to judicial scrutiny, and under what circumstances this can be subjected, which is more than procedural, that is something which, of course, in a country of this kind, we are all governed by the Constitution, is for anybody who is really feeling exceedingly dissatisfied and taking a resort to that. But I don't think that is something which, frankly speaking, has ever been done, and it would be quite unfortunate if a recourse is taken to that on the ground that the power of the upper house is in this way curtailed, because once it has been classified, then of course the Constitution is quite clear on the procedure to be followed in regard to the passage of the money bill.
But Mr. Singh, my question, the same question which I asked Mr. Acharya also, the seventh clause in that Article 110, which says any matter incidental to any of the matters specified in subclauses A to F. Now, doesn't that give scope for you know, some kind of a expanding the scope of what this Article 110 is all about, and gives that much more leeway to a government to classify whatever bills as a money bill?
I don't think so, because I think that these powers have been given to be exercised with the appropriateness, discretion, judgment, which the Constitution naturally, for very good reasons, has reposed in the judgment of the Speaker representing the House of the People. And I believe that these powers have not been transgressed. So the question of casting any shadow of doubt on the rationality and appropriateness of the Speaker's decision has not arisen,
no, but
and I'm sure
don't you think
that
it arose
will not arise in the future as well.
Sorry to intervene.
Of course.
Sorry to intervene, sir, but don't you think that question arose when the black money bill was, you know, was seen as a money bill and it got passed? Don't you think that question was raised then?
Yes, that question arose, and that question was raised, and that question was also settled. It was settled that the decision of the Speaker is what prevailed in accordance with the provisions of the Constitution, and that is how these bills were enacted and have now subsequently become part of our legal rubric.
Okay. Mr. Acharya, you think that issue is settled now?
Well, I would agree with Mr. Enger Singh that so far as that point is concerned, that stands settled. Because the Speaker has certified it as money bill, and as far as the Constitution is concerned, that is the final thing.
That is the final word.
So,
if that is the case, then my question is this. Then what stops what stops other bills which are going to come up? Maybe it is a GST also to be certified as a
GST can't be.
Or any other bills which are going to come up. We are only talking of land bill, which is also one of the important important legislation on the agenda of this government to get it passed. Now, can land bill be a money bill?
Well, you see, the point is, as I said in the beginning,
completely far-fetched too.
No, I'm sorry. I understand, sir, it is far-fetched, but I'm just trying to understand the scope to which this can be expanded.
Well, to reply to your question,
yes.
The point is, as I said in the beginning, the Constitution has cast a certain faith in the Speaker, because the Constitution makers believe that the Speaker would take the correct decision. And as Mr. N.K. Singh has said, this question has never arisen actually. If it arises, then of course people have to think about the other ways of resolving this issue. But so far it has not arisen.
So far it has never arisen.
In the case of this black money bill, there were doubts expressed by the members of the Rajya Sabha, and they raised it. And perhaps the chairman, they came before the chairman and they placed these points before him. But the chairman, of course, reminded them about the constitutional provision.
Exactly. There is not much that the chairman can do as far as...
The chairman cannot do anything except to point out to the members about the existence of this article, the power of the Speaker. So that is where it should rest normally. But in case a situation arises where there is a blatant kind of exercise of wrong exercise of power in this matter, then of course the people may think about taking recourse to other remedies. That is okay, but at the moment perhaps it is not possible.
Smita, we are only discussing these two bills. There are other bills which are pending before the government to get it passed. You think that there are any such bills which the government or some people in the government feel that they can do it, they can do this way?
Well, as was explained to us by people in government, that many bills have some kind of a money component.
Element of money in it.
Yeah, meaning like suppose it's something to do with some rural development program or something, say, so there is no money involved. So that is the explanation they gave. Maybe it's a facile explanation, but it's obviously something that they're thinking about. And if Mr. Acharya suggested that there is some scope for a judicial intervention, but otherwise there's always public opinion.
Of course, public opinion. Mr. Singh, see, one of the clauses in Article 112 says the appropriation of monies out of the Consolidated Fund of India. Now, this is something, as Smita was pointing out, and as some people in the government have been talking to journalists, and she was mentioning that, this is a clause which can be really, expanded and interpreted to bring in virtually any bill will have some amount of some money which is coming out of the Consolidated Fund of India.
Well, I think that I'd just like to make two observations. First is that I think that if technically speaking we know that the demand for grants, which is really basically outgo from the Consolidated Fund of India, are debated and then approved, or they are guillotined at the end of it.
Right.
So there is a parliamentary sanction in respect of the outgo from the Consolidated Fund of India, which is contained in the appropriations bill itself, which is introduced as part of the union budget. So that part of it is clear. But let me give an example which may be of interest. Just because it pertains to securing money into the Consolidated Fund, then in that case, really speaking, one or two bills which could have been at least examined or would have been the insurance bill, it largely would lead to the garnering of huge resources for long-term capital into the country's direct foreign investment for purposes of insurance, or the pension bill, which would really result in a huge inflow into the consolidated fund via the pension funds making investments. But they were not classified. And there was no attempt made to classify them, even though they primarily dealt with increasing the resources of the consolidated fund of India through direct foreign investment. So there has been precedence, there has been a judgment. These judgments have been exercised with a great amount of reason, a great amount of caution, and I do not see really any imminent danger or any nascent danger of the provisions relating to the money bill prescribed fairly tightly under Article 110 of the Constitution to be misused in a manner which would not really be appropriate in accordance with the spirit and in accordance with the checks and balances which the Constitution has provided.
Mr. Singh, you know, your point very well taken. I hope everybody takes that point seriously. But my question is, as far as pension and insurance are concerned, of course, there were a lot of opposition to it. There were a lot of... but at the end of the day, there was agreement on by the two main opposition parties. Now, why I'm asking you this question, and I want Mr. Acharya also to talk on that, is that in the coming days, the kind of atmosphere which is prevailing in the Parliament today, and in the coming days, what could prevail, the kind of strife which we witness, so that could become the reason or the ground for maybe this kind of exercise of power of expanding the scope of Article 110. That is the concern of some people. Don't you think that concern is a valid concern?
My own feeling is that these concerns are misplaced. The misgivings need to be allayed. That government is committed to following the letter and spirit of the Constitution in regard to treatment of money bills, and I don't see any danger whatsoever of these articles being subjected or being misused in a manner which contravene the basic spirit and features of the Constitution.
Okay.
So I think that these misgivings, frankly speaking, are totally misplaced.
Okay. Mr. Acharya, would you say the same thing?
Actually, what I have to say about this is the appropriation from the Consolidated Fund of India, which is mentioned in Article 110, means the appropriation bills, which are passed by the houses after the demands are passed. It basically, as far as I know, it basically deals with that, because appropriation out of the Consolidated Fund of India. Now this comes under Article 110, which means only the appropriation, only if a bill contains only appropriation, only then it becomes a money bill. If it contains something else also, then it is not a money bill.
So that means that there is a scope for interpretation.
No, there is no scope for interpretation.
There is no scope for interpretation.
So far as this appropriation is concerned, there is
no scope for interpretation. But there are,
according to me, absolutely there is no scope for interpretation.
As far as these 6 clauses plus 1 is concerned under Article 110, you don't think there is any scope for interpretation?
I don't think there is much scope in that. Of course, the 7th one, the last one says...
The last one...
Incidental.
Okay.
But then...
Smital, very quick last words to you. You think that, this is an issue, as Mr. Singh says, the concerns are misplaced, or you think that we need to keep a watch?
No, I'll pick on something else that Mr. N.K. Singh also said. He says these misgivings need to be allayed. He said that earlier.
Yes.
So I think, I hope Mr. N.K. Singh's words, those words are heard.
Okay. Misgivings need to be allayed, but this is a debate which needed to be debated, and hope it will be debated further also. Thanks to all my guests. Please keep watching. We'll come back with another issue, The Big Picture, same time tomorrow.